Let's speak now to Advocate Paul Hoffman, Director and Head of Projects at Accountability Now, who's joining us, of course, for his reaction. Advocate, good evening and thank you very much for your time. First and foremost, the legal standing of the recommendations. I'm a little bit worried when the President's response says that the response may also be a decision not to implement a recommendation, setting out reasons. We may also inform and advise Parliament that a recommendation overlaps with existing work currently underway within government. Where does that put the legal standing of these recommendations?
Yes, thank you, Tabo, and good evening to your viewers. The general proposition that the findings of fact and the recommendations of a commission of inquiry, such as the Zondo Commission of Inquiry, are not binding is a correct statement of the law. The Commission of Inquiry is simply an extension of the executive of the country, and it is given a particular mandate to investigate a complex issue and to find out what the true story is in relation to the complex issue and to make recommendations to the executive. Nobody is bound by the findings of fact, and the recommendations that are made to the executive are not of the obligatory kind. They take it or leave it sorts of recommendations. Now, there is an exception to that, and that is when a recommendation actually simply enunciates and applies the law to the particular facts that are established. So in this Commission of Inquiry, it has been established that the ANC, as you've just been discussing with Mr. Mabe, has this practice of cadre deployment in the public administration and the state-owned enterprises. Now, that practice has been struck down by the Eastern Cape High Court in the Amatola District Municipality case years ago. The court found that cadre deployment of that kind is illegal and unconstitutional. And the finding of the Zondo Commission of Inquiry in relation to cadre deployment was really that it was a major cause of the trouble and that it ought not to continue because it is not in line with the constitutional principles that apply to human resource management in the public administration and the state-owned enterprises. Now, you've just had a very interesting conversation with Mr. Mabe about it, but the President did not mention it at all in his address to the nation tonight, which leaves us in the default position that the ANC insists on continuing with this illegal and unconstitutional practice that caused state capture in the first place. So that is a very worrying silence on the part of the President and a worrying attitude on the part of Pule Mabe. You know, you've got to think no further than Tony Yengeni. He did wrong. He was convicted of defrauding Parliament. He went to jail. And today, far from distancing themselves from him, the ANC allows him to occupy a senior position in its National Executive Committee, where he is in charge of crime and corruption, which really makes a nonsense of the entire thing. But think of Jacob Zuma. Why is he still a member in good standing when he has been found guilty of contempt of court and has really done nothing to forward the integrity of the ANC in any way for a very long time? He is still inside the party. He feels free to stand up and say that President Ramaphosa is treasonous and corrupt, and the ANC just embraces everybody and carries on as though this is perfectly normal behavior in a functioning political party. Do I ever agree with the NEC that the President ought not to be directly elected in South Africa? the stakes are far too high for that, and it is preferable by far that the majority of the National Assembly elect the president.
Let's talk then about the creation of a permanent anti-corruption commission and public procurement and anti-corruption agency. The president says in terms of actions, they've given this task to the National Anti-Corruption Advisory Council, which will, in the course of work, advise on the strengthening of the country's anti-corruption institutional arrangement. Consider the detailed recommendation of the commission on the establishment of the Anti-State Corruption Commission and a public procurement anti-corruption agency by the end of the current financial year. Is that something that will take a lot of doing in your view?
Well, the National Anti-Corruption Advisory Council has been given a 3-year lifespan by the president, which to my cynical mind suggests an attempt to kick the can down the road and not grasp the nettle as one should in relation to a matter as serious as this. But the other aspect, besides the problems created by forming NACAC, the other aspect that is problematic on this front is that, similar to that with cadre deployment, the courts have already determined what the criteria are for establishing effective and efficient anti-corruption machinery of state. This happened in the Glenister litigation, which ended in 2014. Needless to say, the Zuma administration had no appetite for putting effective and efficient anti-corruption machinery in place. On the contrary, that administration was very busy firing the National Director of Public Prosecutions on the flimsiest of bases and in a corrupt manner, which the NPA has never done anything about, and hollowing out the entire criminal justice administration so as to ensure that those involved in state capture could continue with their corruption with complete impunity, which is the case to this day. Nobody since Jackie Salebi and John Block has actually gone to jail for corruption and for being involved in corrupt activities as a deployed cadre of the ANC. So the recommendations that need to be made or the steps that need to be taken by government are not as complicated as the commission would have it. The task at hand is simply to implement the binding criteria laid down in the Glenister litigation. They're very simple. You have to have specialized, well-trained personnel who operate and are structured independently, who are fully resourced and secure in their tenure of office. Now, you can't say that about the Hawks, you can't say that about the NPA, and you can't say that about this new little unit that is. So
you're saying the ID investigators, which the president says will provide for greater, I suppose, scrutiny and investigating capacity, saying to further strengthen the current anti-corruption capabilities, the investigating directorate will be established as a permanent entity within the ID as per the Criminal Procedure Act number 51 of 1977. Are you saying that is not the body that you envisage?
It's not. It's not going to be adequate. What he's talking about there is something very similar to the Scorpions. Now, what the NEC of the ANC was talking about in August 2020 was a standalone, independent, permanent corruption-busting body, which is much more in line with what the law, as laid down in the Glenister cases, actually requires. The Cabinet has never acted on the NEC resolution of August 2020, and what we have now is a reversion to a Scorpions-type body, but look how easily the Scorpions were closed down. Unless you give secure tenure of office, which you can do by locating the anti-corruption machinery of state within Chapter 9. You see, the Scorpions were closed down with a simple majority in Parliament. You will not be able to close down an anti-corruption entity that is located in Chapter 9 because you would need a 2/3 majority, and I think it will be a long time before any party has a 2/3 majority in the South African Parliament. If anything, we're getting more parties, not less.
We appreciate your time. Let's leave it there for tonight. That's Accountability Now Director, Adv Paul Hoffman.